Hello everyone! We're sharing with you a video on a recent joint webinar PortCalls had with the Philippine Multimodal Transport and Logistics Association on the Anti-Money Laundering Act. We hope you find this video informative. Let's begin by calling in Ms. Marilyn Alberto, President of the Joint Philippine Multimodal Transport and Logistics Association, to deliver her welcome remarks. Good morning, Mrs. Alberto.
Hi, good morning, Marielle, and good morning, everyone. On behalf of the Philippine Multimodal Transport Logistics Association and PortCalls, we'd like to thank you for signing up for this webinar on Anti-Money Laundering Act and how the logistics industry can comply. As we have always done, we are going to tackle an issue of concern that members of PMTLI and the transportation and logistics industry should be aware of. Have you ever heard about trade-based money laundering? It is the moving of criminal funds through trade transactions or import and export of goods to disguise their origins. Are you also aware that bank accounts of several forwarders and carriers were recently frozen due to suspicion that these were used for money laundering by some unscrupulous traders? Considering these developments and the huge amount of both local and international transactions that we handle in the course of our daily business, we believe that an understanding of the Anti-Money Laundering Act is extremely crucial. This morning, we will learn about key provisions of the Anti-Money Laundering Act from our first speaker, Anti-Money Laundering Council Secretariat Deputy Director, Attorney Ronel Buenaventura. This webinar will help us become aware of our exposure to local and international regulatory and enforcement risks, and at the same time guide us on the best compliance practices and detailed steps to take when an account is flagged. In addition, he will dispel commonly held misconceptions about the law. I will wish you all a productive and learning-filled morning.
This is Alberto. Attorney Ronel U. Buenaventura is currently the Acting Deputy Director of the Commitments and Policy Group of the Anti-Money Laundering Council Secretariat. He has worked as legal officer of the Bangko Sentral ng Pilipinas and as Associate Solicitor of the Office of the Solicitor General. He is also a law professor, book author, and bar reviewer. He graduated class valedictorian and magna cum laude from the College of Law of Bulacan State University and ranked 10th in the 2015 bar examinations. He finished MA Philosophy and BA Psychology from the University of the Philippines, Diliman, in 2011 and 2009, respectively. Ladies and gentlemen, let us all welcome Attorney Ronel U. Buenaventura. Good morning, Attorney.
Good morning, Marielle. Thank you for that gracious introduction. May I request to share my screen?
Take it away. The floor is yours.
All right, so I hope everyone can see the screen already. So I'll begin my presentation. So good morning, everyone. Good morning, PortCalls. Good morning, Miss Alberta. Good morning, Marielle. I'll be presenting the Anti-Money Laundering Act, some salient provisions, and based on the theme for today is how logistics industry can comply. So to begin with, I would like to show my flow of presentation. And I would like first to introduce our organization, the Anti-Money Laundering Council, and then we will proceed to discuss the crimes of money laundering and terrorism financing, just a bit on terrorism financing because it's also part of the mandate of the Anti-Money Laundering Council and is usually tied up with money laundering. And then we'll discuss about covered persons and then how we investigate and prosecute money laundering offenders or money launderers. So to begin with, I would like to start with the Anti-Money Laundering Council or the Amlc. So the AMLC is created under the Anti-Money Laundering Act or RA number 9160 as amended. And it's our aim to be, of course, a world-class financial intelligence unit that will help establish and maintain an internationally compliant and effective anti-money laundering regime. Our mission, which is basically the state policy of the Philippines in as provided under the Anti-Money Laundering Act, is to, number one, preserve and protect the integrity and confidentiality of bank accounts. Number two, to ensure that the Philippines shall not be used as a money laundering site for proceeds of any unlawful activity. And number three, to extend cooperation in transnational investigation and prosecution of persons involved in money laundering activities wherever committed. We take note as early as of now that money laundering is a transnational offense. It cuts across borders. So there are elements of money laundering or part of money laundering that may be committed abroad and is being continued here, or the unlawful activities or the predicate offenses of money laundering are committed abroad, and then the money laundering is committed here in the Philippines. So we really extend international cooperation in terms of investigation and prosecution of persons involved in money laundering. The AMLC is likewise been empowered by the Terrorism Financing, Prevention and Suppression Act, or the RA 10168, as well as the recently enacted Anti-Terrorism Act, to investigate, prosecute those who are involved in financing of terrorism, and to a certain extent to those involved in terrorism. We'll be discussing those key concepts later as we go along with our presentation. Our council, or the Amlc, is composed of three persons or three members, with the governor of the Bangko Sentral as our chairman. And as members would be the chairperson of the Securities and Exchange Commission and the commissioner of the Insurance Commission. And right now, the governor of the Bangko Sentral is the Governor Benjamin E. Jokno. The chairman of the SEC is Chair Emilio B. Aquino, and the commissioner of the Insurance Commission is Dennis B. Funa. So they act in all actions taken by the AMLC under the law. They act unanimously in the discharge of their functions. So every actions taken by the AMLC have been approved by the three of these members or officers or council members. And in support of the council is the Secretariat. The council established the Emlc Secretariat to assist in the discharge of its functions. So in accordance with that authority, the council was able to, it has the authority to determine the appropriate offices and the number of personnel. So right now, and we are part of the Secretariat. That's why perhaps you may have heard AMLC or AMLC Secretariat. But basically, the AMLC Secretariat is still part of the AMLC. It's just that we do the work, while the council approves and gives the policy. So right now we have our basic organizational chart as stated, as shown in the slide. So to give an overview of the major functions of the AMLC, there are actually four. The first one is that it is the Philippines Financial Intelligence Unit that receives and analyzes covered and suspicious transaction reports from covered persons. We'll discuss more about these covered transactions and suspicious transactions in a while. And then the AMLC also performs reliable investigative and prosecutorial services, which makes it a hybrid financial intelligence unit. In other countries, financial intelligence unit, they are simply limited to analyzing or receiving of covered and suspicious transaction. But our Anti-Money Laundering Council allows or is empowered to investigate money laundering and terrorism financing, as well as filing of cases, forfeiture proceedings, and criminal cases for money laundering and terrorism financing. The AMLC is also an efficient supervisor, ensuring compliance of covered persons with anti-money laundering and counter-terrorism financing laws, regulations, and other issuances, which in turn ensures that their money laundering and terrorism financing risks are well managed. Finally, the AMLC provides overarching support services. It's also the representative of the government in money laundering and terrorism financing cases. So that overarching support services would include our international commitments to international bodies, as well as policy development in terms of money laundering and terrorism financing. Now and again, as mentioned earlier, all the Anti-Money Laundering Council is created under Republic Act 9160. It was passed, or that's our original Anti-Money Laundering Act or Anti-Money Laundering Law. It was passed in October 17, 2001. This was the law was passed partly or major in part because of our international commitments that the Philippines shall not be used as a money laundering site. At that time, the Philippines was assessed to have no particular law on money laundering. And we were blacklisted at that time by the international community. And because of that, Congress deemed it proper to pass Republic Act 9160. But throughout the years, there are clamor from the international community to strengthen the Anti-Money Laundering Act, and hence there are subsequent passages of law amending, empowering the Anti-Money Laundering Act, Anti-Money Laundering Council. So we have Republic Act 9194, 10167, 10365, 10927. 10927, which was passed in July 29, 2017, included casinos, including internet and ship-based casinos as covered persons. And then finally, in Republic Act 11521, which took effect early last year, included the offshore gaming operators or the POGOs and their service providers, as well as real estate developer and brokers as covered persons under the Anti-Money Laundering Act, and the violation of Strategic Trade Management Act and tax evasion as predicate offenses of money laundering. So been mentioning this, so I'll be discussing now who are covered persons, what are these predicate offenses, what are covered in suspicious transaction reports. So let's now proceed with the crimes of money laundering and terrorism financing. So let me begin with money laundering and how we arrive with the term money laundering. So basically, when we say money laundering, it's laundering of money. Laundering of dirty money. Why do we launder money? Because it is dirty. That's why it's we launder in money laundering, there is laundering of dirty money. And why do we say that money is dirty? Because that money was derived from an unlawful activity or proceeds of an illegal act. That's why it's called dirty money. And what we want, or money launderers want to do with dirty money, of course, is to make it appear clean. So in money laundering, essentially, you are the perpetrator is laundering the money the dirty money, which is a proceeds of unlawful activity, to make it appear clean, so that the launderer can use that in legitimately, or at least give the appearance of legitimately. We adopted, in our jurisdiction, money laundering from the Palermo Convention. So United Nations Convention Against Transnational Organized Crime, or the Palermo Convention. So basically in this, we can see we have the conversion money laundering would involve conversion or transfer of property, knowing it is derived from a criminal offense for the purpose of concealing or disguising its illicit origin, or of assisting any person who is involved in the commission of the crime to evade the legal consequences of his actions. Or it may also involve concealment or disguise of the true nature and source of the location, or the mere acquisition, possession, or use. So you either acquire, possess, or use, or conceal, disguise, or convert, or transfer a proceeds of unlawful activity, then you may be held liable for money laundering. But an important prerequisite here, as you can see, is the underlined word knowing. In the definition of money laundering, knowledge is very important. And in criminal law, the intent and knowledge required to prove includes the concept of the mental state. So the person who is doing this must be aware that he is indeed doing money laundering. He knows that the proceeds of unlawful activity are being used, or is using it, concealing it, converting it, or transferring it. So do not be alarmed if later on you were for some reason entangled in a money laundering activity. But if you can show that you have no knowledge of that activity, then you are not liable for money laundering. Because crucial here, and perhaps in criminal law, definitely there must be a concurrence of the criminal mind. It's very important. It's a basic concept in our criminal laws that there must be a criminal mind before you can commit before you can commit a crime. And so it's true in money laundering. However, sometimes we cannot, there are instances where we cannot simply feign ignorance. So we know that money laundering is happening, but we choose to ignore that. And will that be counted against us in terms of knowing? Yes, it will, because in our jurisdiction we may also apply the concept of, or legal principle of, the so-called willful blindness. The courts have defined willful blindness as the deliberate avoidance of knowledge of the facts or purposeful indifference, and have held that willful blindness is actually equivalent to actual knowledge. So, for instance, alam mo sa bahay mo na yung kapatid mo ay engaged sa, say, illegal drugs, selling of illegal drugs, which is an unlawful activity. Nakita mo yung drugs sa bahay, nandyan, nakakalat, tapos nakita mo, nagbebentahan, tapos yung pera na kinikita ng kapatid mo, binibigyan ka. That is a proceed of unlawful activity, and the acquisition or possession of that may amount to money laundering. Pag binibigyan ka, tapos pinambibili mo, then that is a money, that may constitute as money laundering. Kahit na alam mo or hindi mo nakita directly yung bentahan, pero alam mo na yung pera na yon for that particular circumstance would fall under money laundering, or would be proceeds of money laundering, then that would constitute as knowledge, because that may fall under the willful blindness. But now let's go to as defined under our law. It's basically adopted. We basically adopted that Palermo Convention, the definition and the acts involved in money laundering. So here we can see the word, how do we commit money laundering? So for us to avoid committing money laundering, we must know how we can commit money laundering. So of course, apart from knowledge, we have the acts involved, transactions of said monetary instrument or property. How do we transact? Kung alam mo na yung pera ay galing sa isang illegal na activity, how do we, and you use that money to, say, to buy a property or to donate buy property, donate, deposit, that is already a transaction. You open an account, you deposited there the money, that is one transaction already. And you are already liable for money laundering under letter A. Then we have converts, transfers, disposes of, moves, acquires, possesses, or uses. So these are actually ang daming verbs, pero let's say for instance transfers. You receive money proceeds of money laundering and then transfer mo or binigay mo sa kapatid mo. That is already a transfer of the monetary instrument, which is a proceed of unlawful activity. So that's already counted as a transfer of for purposes of money laundering. One count na yan ng violation. Disposes of, yung example kanina, dinonate yung pera, nag-donate ka sa charity, even if it is for charitable purposes or noble purposes, that is already money laundering. You move the money. How do you move the money? Naka-receive ka ng pera, proceeds of unlawful activity, dinala mo abroad, nag-abroad ka. That is moving of monetary instrument or property that may be considered as money laundering. Acquires, possesses, or use. I think they are self-explanatory. Oh, I forgot the word converts. You receive money from an unlawful activity, money, pera, and then anong ginawa mo? Ginawa mo manager's check or ginawa mo manager's check tapos binigay mo, pinambayad mo sa iba, or you receive that money in Philippine peso and then you converted it into dollars or a foreign currency. That is conversion. So that is already one count of money laundering. And then conceals or disguises the true nature, source, location, movement. So basically, I forgot to emphasize, in money laundering, what is involved is not only money. It may be monetary instrument or even property. So, halimbawa, you got a proceeds of, say, in corruption or bribery or corruption of public officials, you got a piece of property or land in the name of another person, which is a proceed of an unlawful activity. So, gusto mong itago yung true nature or source nun. So, pinangalan mo sa ibang tao yung property. So that may amount to concealment or disguising the true nature or source or location of that property. Then attempt to commit money laundering, conspiracy to commit money laundering, or those who even aid or abet in helping people to commit money laundering, then they are also liable. Then all persons who performs or fails to perform any act in relation to those mentioned would also mean that they are liable for money laundering. So that is a sin of omission. So you omitted to perform an act, then you can be held also liable for money laundering. But again, wag po matakot kasi sinabi nga natin, there must be an element of knowledge or knowing. It's very important. Kung hindi mo naman alam, then you can use that as a defense if you are prosecuted later on. We keep on repeating the word unlawful activity. So ano po ba yung unlawful activity na sinasabi natin dito? Okay, unlawful activity here does not refer to all crimes. It does not refer to all illegal acts. Yung tingin nyo na illegal or yung alam nyo na illegal, hindi po lahat pumapasok doon. There are actually enumerated unlawful activities under the Anti-Money Laundering Act as amended, and there are 36 enumerations, 36 enumerated predicate offenses or unlawful activity. Although 36 po yung enumeration, it doesn't mean that there are only 36 because in some enumerations, there are clustered or lumped together certain offenses. So I think in one enumeration, there is kidnapping. In one enumeration, there is hijacking, destructive arson, and murder. So basically, there are 3 different crimes, but they are enumerated in one paragraph. So, and then of course, as you will notice, in these crimes that unlawful activities, there is a proceeds. of unlawful activity, or there must be proceeds of unlawful activity before you can say that there is an unlawful, there is a money laundering, because what we are laundering here would be the proceeds of these 36 enumerated predicate offenses. When we say, okay, I'm just flashing here the summary of the predicate offenses. Medyo maliit po, but we can see this essentially in the law. But we can categorize these unlawful activities into different groups or major groups. We have the corruption-related offenses, which include violation of the anti-graft and corrupt practices, plunder, bribery, fraud, malversation. Then we have trafficking or exploitation related crimes, so violation of the Anti-Trafficking in Persons Act, Anti-Photo and Video Voyeurism Act, Anti-Child Pornography. We also have property crimes. We have robbery and extortion, qualified theft, violation of the Intellectual Property Code. We also have fraud crimes, and I think you may already be aware already. Smuggling is an unlawful activity. Violation of tariff, smuggling as by pursuant to the violation under the Tariff and Customs Code or Customs Modernization Act of the Customs Modernization and Tariff Act. Then we have violation of the Securities Code, violations of Strategic Trade Management Act. Then we have terrorism-related crimes, so terrorism and conspiracy to commit terrorism, and then financing of terrorism. Other financial crimes, so kidnapping for ransom, violation of Dangerous Drugs Act, wetting, masyao, hijacking. So these are the unlawful activities or the predicate offenses. Bakit po ba tinatawag na predicate offenses? The law termed them as unlawful activities. Bakit po ba tinatawag na predicate offenses to? Because money laundering is actually a derivative offense. We need to have an existence first. There must be established first an existence of these unlawful activities before we can have money laundering. Kumbaga, there must be first, it must be shown na kailangan may crimes muna na ito before we can proceed with money laundering. That's why money laundering has been termed as a derivative offense. Kailangan, na-derive lang yung offense na to because there is a prior offense or a predicate offense. The offense from which the money laundering is predicated. So we need first to have these predicate offenses. Do we need to secure conviction first? Pwede po ba ako i-prosecute? Wala pa namang conviction ng predicate offenses? Hindi po. We don't need conviction of the predicate offenses. We don't need a person to be convicted of dangerous drugs or drug importation or smuggling before we can prosecute them for money laundering. The law only requires that there must be existence. Paano po if later on na-acquit naman or hindi naman po guilty for predicate offenses? It may be, but under the law, they proceed simultaneously. Pwedeng mag-proceed si predicate offense, you can be charged and be acquitted, or meaning hindi ka namang guilty, pero pwede pa rin magtuloy ang money laundering. Kasi magkaiba ang predicate offenses sa money laundering. In fact, you may not be even involved in the commission of the predicate offenses, but you may be involved in money laundering. Pwedeng hindi ka naman talaga nag-commit, hindi ka naman kasali doon sa mga nag-smuggle ng goods, hindi ka naman kasama doon sa nag-engage sa corruption of public official, hindi ka naman kasama sa naglagay, pero pwedeng kasama ka makasuhan ng money laundering. Because they are two different elements, so to speak. Magkaiba yung crime na predicate offenses sa money laundering. As we have shown here, what we're looking for is that there must be an unlawful activity, whether you participated or not, irrelevant kay money laundering. But there must be shown an existence of unlawful activity, and that unlawful activity produce proceeds or dirty money or property or monetary instrument, and then you perform any of the acts or transactions that we've mentioned here, transact, converts, transfers, and the more important, one of the most important would be, and equally important would be, there must be knowledge. There must be knowledge. Paano po pag walang knowledge? You may be held civilly liable. Ano po yung civil liability? Kung napatunayan na yung pera na galing na nakuha mo ay proceeds of unlawful activity, maaring hindi ka nga kasuhan criminally for money laundering, but pwedeng kuhanin ng government yung proceeds of unlawful activity that are in your possession. Which we will discuss in a while. Paano ba kinukuha ng government yon? But under the law, you may be held civilly. Walang criminal case, but civil liability kasi it appears na nabigyan ka or nakuha mo yung proceeds of unlawful activity. The government has the right to go after these proceeds. Okay, so there is a second, as mentioned earlier, money laundering is generally a derivative offense. Kailangan ma-establish muna natin yung predicate offense. But in money laundering, it may also be committed on itself without need of predicate offense, but this only applies to covered persons. If a covered person fails to report a covered or suspicious transaction, knowing that it is a covered or suspicious transaction, then they can be held liable for money laundering. So we'll discuss them in a while. But the usual stages of money laundering, or at least the internationally accepted ways of or stages of money. I'm not teaching you how to launder money, but I'm telling you because this is the internationally accepted or known stages of money laundering would be placement, layering, and integration. In placement, the cash or other assets which were derived from criminal activity is or being introduced by the money launderer into the financial system. So for instance, banks. So this is more often than not, this is accomplished by placing the funds into circulation through formal financial institutions, casinos, or other legitimate businesses, both domestic and international. Then we can have layering. In layering, the proceeds of illicit, the separation of illicit proceeds from their source of layers of financial transactions intended to conceal the origin of the proceeds. So anong ginagawa dito? They convert it and create multiple layers or complex layers of financial transaction to hide the source and ownership of funds. And then once na apparently legitimate na kasi kaiikot ng pera, then it will now be reintroduced into the economy, and that is called the integration in what appears to be a normal business of personal transaction. This stage entails using laundered proceeds in seemingly normal transactions to create the perception of legitimacy. For instance, the launderer might choose to invest in funds in real estate, financial ventures, or luxury assets. So we can see here a typical money laundering scheme. So you collect dirty money, you place it in a financial institution or casino, and then you layer it. So you transfer it to the account of Y, then you wire transfer it offshore, and then you obtain a loan, you use that offshore account as a collateral perhaps, or you get money from that offshore account, you use that to pay an invoice into a shell company or a fake company, and then once this has been layered, you now reintegrate it to the economy for the purchase of luxury assets. Question would be, kailangan po ba makomplete ni money launderer yung placement, layering, integration before it can be prosecuted for money laundering? The answer is no. Because if you can recall, mere transaction of proceeds of unlawful activity would already be considered as a violation. So, nandito ka pa lang sa placement, sa unang-una, you can be held liable already for money laundering. Unang count pala. Paano po halimbawa na kumpleto niya to? Nag-placement siya, nag-layering, inikot niya wire transfer, niloan sa company, ginamit as payment for an invoice in another company, and then integration. So, ano po mangyayari dyan? Then that money lender can be held liable for as many counts of transactions, conversions, transfers as he had done in that scheme. So for instance, ito, in placement 1, layering 2, 3, 4, 5, 6. 6 counts of money laundering. That's why in our investigation and in filing cases, in our filing of cases in money laundering here with the AMLC, we really file cases usually 32 counts, 100 counts, 54 counts of money laundering. Because every act we deem, every act of transfer in bank account, every act of payment, every act of movement of money is counted as one violation of money laundering. Kaya pag nagpo-file kami ng cases in money laundering, lagi 24 counts, 50 counts kasi paano namin matitrace yun? When we check the bank transaction, titignan lang po namin ilang beses niya nilipat yung pera. Lipat-lipat yung pera. Can we track that? Yes. Sa bank, lagi silang may paper trail. Kung ilipat mo sa kabilang bangko, titignan lang namin yung susunod na bangko. Kung ano ang ginawa mo dun sa pera. Or kanino napunta yung pera. So, it's very easy to count every transaction. Kung in-online mo yan, dineposit mo yan, then it can easily be seen in bank documents or other financial instruments. Kung remittance yung ginamit mo, we can easily track that as well. So some sample methods of money laundering siguro just a typical or an example would be say in leasing, a property is rented by a tenant so who is provided with illicit funds to cover payments, and then alternative is for the criminal to make regular deposits into an account as fictitious rent, giving the appearance of legitimate income. We also have the shell company. It's created only for the purpose of using it in for money laundering. You purchase property through a shell company. Yung shell company hindi talaga nag-ooperate. Create mo lang para to use for a say illegal activity like money laundering. And then pinapangalan mo doon yung property so that the property, the name of the owner of the property will be kept secret. Yung iba ginagawa yung undervaluation, overvaluation sa real estate or property or even in normal property, hindi mo kailangan real estate. And then yung difference will be settled in secret cash payment. No, money laundering is an ever-evolving activity. It must be continuously monitored in all its various forms in order for measures against it to be timely and effective. So definitely a money launderer will seek to operate in and around the financial system in a manner that best fits the execution of the scheme to launder funds. So we really the AMLC is really fighting against a lot of money launderers. So let's leave briefly money laundering, but I want to introduce you to the concept of terrorist financing or financing of terrorism. So basically in financing of terrorism, we have the financial support in any form of terrorism of those who encourage or plan or engages in terrorism. The financing of terrorism is defined under Republic Act 10168 or the Terrorism Financing Prevention and Suppression Act of 2012. So basically, if you provide any support, financial service, property, or other related services that may up to a terrorist or terrorist organization or those who plan or engages in terrorism, then you are held liable for financing of terrorism. So, hindi po kailangan na pera dito if you have, say, goods at pinadala mo yan sa isang known terrorist or you know him to be a terrorist activity, engaged in terrorist activities, then you can be held liable for financing of terrorism. You can also be held liable for prohibited dealing under the terrorism financing law if you give support to those or deal in any way to those who have been designated as terrorists. I think in our local setting, the Anti-Terrorism Council has already designated communist terrorist groups and local terrorist groups. If you provide support to these groups, whether financial support or goods in terms of goods, then you are also liable for dealing with at least dealing with this prohibited liable for prohibited dealing under Section 8 of the Terrorism Financing Law. If not, or under Section 4 on financing of terrorism. But let me just give a brief differences and similarities between terrorism financing and money laundering. So they are, both of them are often mentioned in the same breath without much consideration to the critically important differences between the two. Many of the controls that businesses should implement are meant to serve the dual purposes of combating both money laundering and terrorist financing. In 2015, the U.S. Terrorist Financing Risk Assessment noted that controls instituted to combat money laundering have also strengthened the ability to identify, deter, and disrupt financing of terrorism. But between the two separate crimes, and although no one has been able to create a workable financial profile for operational terrorists, there are key distinctions that can help us understand differences between the two. The most basic difference would be the origin of funds. Terrorist financing uses funds for an illegal political purpose, but the money is not necessarily derived from illicit proceeds. The purpose of laundering funds intended for terrorists is to support terrorist activities. The individuals responsible for raising the funds are not the beneficiaries of the laundered funds. The money benefits terrorist activity. On the other hand, in money laundering, it always involves the proceeds of illegal activity. The purpose of laundering is to enable the money to be used legally. The individuals responsible for the illegal activity are usually the ultimate beneficiaries of the laundered funds. So, in terms of the amount, in money laundering, it usually involves large amounts. But it doesn't mean that if you launder only 1,000 pesos, it will not be considered as money laundering. It is still considered money laundering, but it's just in comparison with terrorism financing, they do not usually involve large funds. So, and again, the motivation for money laundering is to maintain a lifestyle, while in terrorism financing, it's actually either politics or a particular ideology. And the purpose for terrorism financing is definitely to execute terrorist activities. So in terrorist financing, there are the sources are usually through fundraising, funds through donors or family businesses. That's for legal sources. But for illegal sources, they may involve purchasing or providing goods for services for terrorist acts, procuring restricted materials or goods, and funding from other terrorist groups and committing criminal acts. So based on initial studies, the breakdown of funding usually goes to operations and facilities or infrastructure. Now, okay, let's leave terrorism financing, but I want to introduce you to our international assessor or the intergovernmental body that provides the standards in money laundering, and that is the Financial Action Task Force. So the Financial Action Task Force, or the FATF, is an independent intergovernmental body that develops and promotes policies to protect the global financial system against money laundering. So it is recognized as the global anti-money laundering. Its recommendations are actually recognized as the global anti-money laundering and counter-terrorist financing standard. There are actually 40 recommendations by the Financial Action Task Force, and they require the countries to identify, assess, and understand the money laundering and terrorist financing risk, and to take appropriate actions. So if you actually fail to comply with the requirements of the FATF, then they actually call on countries and place them in a so-called list, a list of non-cooperative countries and territories. So sort of naming and shaming countries. So I think this, I'm just explaining this because I think as the logistics industry is involved in international transactions, you will note that the Philippines has been listed in the gray list, and it may have repercussions under the FATF. Although the FATF has placed the Philippines in its gray list, it does not call for any sanctions, economic sanctions against the Philippines. But if in the event that you are experiencing some countermeasures being imposed upon you as being involved in the logistics industry, in international by international institutions or even by our local institutions, then, and by reason of the Philippines being listed as in the gray list, then you can inform the AMLC so we can make appropriate action and representation. So we have this list, the blacklisted countries. We have gray listed countries. These are countries that were found, well, identified to have perceived deficiencies in terms of money laundering and terrorism financing framework or legal framework. So right now, the Philippines is gray listed, and but the national government has already issued a directive for a whole of nation approach to combat or to address this issue. Now, earlier, Ms. Alberta has mentioned trade-based money laundering, and I would just like to expound briefly or shortly on trade-based money laundering, because as part of the logistics industry, I understand this may be, I think it's important that the industry be aware that there is also the so-called trade-based money laundering. Usually, as explained earlier, there are main methods by which criminal organizations and terrorist financiers move money for the purpose of disguising its origin and integrating it into the formal economy. The first is usually through the use of the financial system. You deposit it with the banks or other financial institutions or through remittances. So, andali lang. Andali, yung pinakamadali. But some would not prefer that because it creates paper trail. Sobrang sabi ko nga kanina, mahanap natin yan. Kasi kung dinaan sa financial system yan, may record si bangko, may record ang mga remittances company, may mga record ang money service businesses natin. So matatrack kung saan dumaan yung pera. So some actually, the second mode by which they perform this money laundering may be through the use of through physical movement of money, such as through the use of cash couriers. So dinadala yung pera at nililipat sa ibang bansa through physical movement of money, and it happens. And we thank the Bureau of Customs for being for setting up a very rigid procedures through to combat this one, the physical movement of money. And the third is this one, through the physical movement of goods through the trade system. Actually, the Financial Action Task Force has focused considerably previously attention on the first two of these methods, but by now there is an international attention given to trade-based money laundering. As we can see, the international trade system is clearly subject to a wide range of risks and vulnerabilities that can be exploited by criminal organizations and terrorist financiers. In part, these arise from the enormous volume of trade flows, which obscures individual transactions, the complexities associated with the use of multiple foreign exchange transactions, and diverse trade financing arrangements, the commingling of legitimate and illicit funds, and the limited resources that most customs agencies have available to detect suspicious trade transactions. Thus, the Financial Action Task Force defined this as a trade-based money laundering, wherein it is a process of disguising the proceeds of crime and moving value through the use of trade transactions in an attempt to legitimize uh, their illicit origins. In practice, this can be achieved through, say, misrepresentation of the price, quantity, or quality of the imports or the exports. Moreover, trade-based money laundering techniques vary in complexity and are frequently used in combination with other money laundering techniques to further obscure the money trail. I just presented here an example of a case study which involved our region in general, and Belgium. So in this case study, a criminal group imports counterfeit goods from Asia into Belgium using a letter of credit and sells them for cash. The group then deposits the money into a Belgian bank account and arranges a subsequent letter of credit. The group purchases additional counterfeit goods from Asia using the new letter of credit, and then these additional counterfeit goods are sold and the receipts deposited in the bank and used to arrange additional letters of credit. So anong ginagawa ng criminal group dito? They were able to use cash deposited in the bank to arrange letters of credit. Subsequently, it was able to make use of these letters of credit to purchase a series of shipments of counterfeit goods. Perhaps the criminal group thought that the use of letters of credit related to trade transactions rather than wire transfers would increase the appearance of legitimacy of these transactions and reduce the risk of detention. But that's what they're thinking because nahuli rin naman sila, or at least this was identified. This typology or way of committing trade-based money laundering has been identified. So with this, we can see that as long as you are creative, as long as the money launderer is creative, they will try to circumvent a lot of they will try to circumvent the law and think of new ways how to commit money laundering. So that's just a brief introduction on trade-based money laundering. Perhaps if we have more, if you are interested, we can have we in our regular annual summit, we usually feature trade-based money laundering as one of the topics we discuss. But perhaps if you want, we can send an invite to the industry when we hold our annual summit, so we can discuss more about trade-based money laundering. And there are a lot of international developments in terms of trade-based money laundering, primarily from the Financial Action Task Force. All right, so let's leave trade-based money laundering, but we'll now proceed with covered persons. Kanina pa po natin naririnig yung covered persons. And in fact, as mentioned earlier, if covered persons fail to report covered or suspicious transactions report, they can be held liable for money laundering. Yun lang yung yun lang yung hindi derivative na crime or derivative offense of money laundering. So who are covered persons? These are persons identified under the law as being sort of covered or included and imposed upon them certain responsibilities and duties. So who are these covered persons? Covered persons are entities that are supervised or regulated by the Bangko Sentral ng Pilipinas, including their subsidiaries and affiliates. Examples of those would be the banks, quasi-banks, trust entities, pawn shop, non-stock savings and loan association, electronic money issuers, foreign exchange dealers, virtual asset service providers, yung mga nag-engage sa cryptocurrency or virtual currency, they are also covered persons under the BSP. So they are, if they're covered persons, they are equally covered under the provisions of the Anti-Money Laundering Act. Insurance Commission regulated industries, companies or industries such as insurance companies, pre-need companies, insurance agents, brokers, reinsurers, holding companies, mutual benefit associations, they are also covered persons. And those covered, those regulated by the SEC, they are securities dealers, brokers, salesmen, mutual funds, investment companies, closed-end investment companies, and other entities or administering or otherwise dealing in commodities or financial derivatives, or basically those who are supervised or regulated by the SEC. They are also covered persons. There are the so-called DNFBPs, or the designated non-financial businesses and professions. Bakit po sila may separate group? Because they do not fall under any of these three categories. They are not regulated by the BSP, Insurance Commission, or the Securities Exchange Commissions. But the law designated them to be covered persons. And not all of them are involved in financial activities or businesses. That's why we call them DNFBPs, designated non-financial businesses and professions. So we have jewelry dealers, dealers in precious metals and precious stones, trust companies, trust and company service providers, lawyers, accountants, and other professionals if they are providing services such as those provided by company service providers, casinos, including ship-based and internet-based casino, real estate brokers and developers, offshore gaming operators, as well as their service providers. With respect to company service provider, if you perform acts such as you render services as a formation agent, or you arrange as for another person to act as a director or corporate secretary, you provide registered, your services would include providing registered office, accommodation, correspondence to a business, or arranging a nominee shareholder for another person, or you manage client money, bank savings, contributions, operations, then you may fall as a company service providers and or lawyers, accountants, and other professionals. So our question would be, kayo po ba sa logistics industry covered persons? If you are performing the activities mentioned, as mentioned, if you manage the client's money, securities or assets, savings, securities, bank contributions, then you may be considered as a covered person, as falling under the designated non-financial businesses and professions. And what would be the duties of these covered persons? These covered persons would have the duties of risk profiling, monitoring of customers, reporting of covered transaction reports or CTR, reporting of suspicious transaction report or STR, training programs, and record keeping. So let's discuss first All right. So they are, of course, primarily they're required to comply with the AML, AMLA law, Terrorism Financing Prevention Suppression Act, as well as the relevant provisions of the Anti-Terrorism Act, including their respective implementing rules and regulation and AMLC issuances. So there are three main duties as provided under the law. We have for covered persons, we have customer due diligence, record keeping, and transaction reporting. So siguro po as engaged in the logistics industry, definitely we open bank accounts, and if you open bank accounts either in your name or on behalf of your company, definitely the banks will conduct a customer due diligence. They need to follow the so-called KYC principle, know your customer. There are a lot of information that they may require from you, such as the basics, yung details, but they may conduct customer identification process or verification. They may also conduct beneficial ownership verification. Sino ba yung ultimate owners ng company, determination of purpose and relationship. Tayo po, pag nag-open tayo ng bank accounts, alam naman natin napakaraming forms na pinifilapan at napakaraming fine print na hindi natin binabasa, or baka binabasa ninyo pero I'm sure baka meron sa iba sa inyo hindi niyo binabasa yung fine print, but of when you open yung application form, but that would include all those information that must be included as required by law and as required by the AMLA or the AMLC. Kung napansin po ninyo, we also indicate in the form sources of funds. Saan ba yung source of funds mo? Ano yung estimate amount or number of times perhaps with deposit or withdrawal, or even the estimate number of transactions or amount transacted. So naka-declare lahat yan. It's part of their customer due diligence or the know your customer. And this KYC is not done only at the beginning kapag nag-open ng accounts, ng bank accounts in case of banks, or pag mag-remit ka ng pera through money service businesses, hindi lang yung first time. They may conduct it simultaneously with the opening or after, or such timing as maybe as required depending on the risks involved. Kung minsan po hindi nyo ba napapansin na tatawag yung bangko, wari may malaking deposit, the bank will call you just to confirm your transaction. Yes, that is part of their customer due diligence. Naka-encounter na rin po ba kayo nung tatawagan kayo after a series of transactions, tatawag na yung bangko, sir, tama po ba ito na may nangyayaring transactions? That the bank may do that. And it's also for your protection kasi baka mamaya nanakawan ka ng cheque or nahack yung account mo, and then the bank would just want to confirm. But also, it's part of their customer due diligence. Bakit ganon? Kasi nakita nila na there may be something happening in your account, so they conduct customer due diligence. And again, depending on the risk involved. These covered persons are required to maintain records for at least 5 years. That's under as required by the law. But paano kung closed account na? So at least 5 years following the closure of the account. But kung may case na na-file, of course, they are required to keep it until ongoing yung case. And failure to keep that account is a criminal offense under the law. Now let's go to the transaction reporting. There are two kinds of transactions that are being reported by these covered persons to the AMLC. The first one is the so-called covered transaction. Ito yung threshold amount na nire-report talaga ng covered persons to the AMLC. So within one banking day, under the law, pwede within 5 working days, but under current regulations, within one banking day, within 5 working days nire-report. under the present, although the AMLC can extend it up to 15 working days. Pero ngayon, within 5 working days siya nire-report. Ano po yung covered transaction? The covered transaction is generally for all that would be 500,000 pesos, either in cash or monetary instrument. Kung cheque ka na 500,000, automatic reported kay AMLC. Nag-withdraw ka 500,000, reported kay AMLC. Nag-withdraw ka ng 500,000, nag-deposit ka, online transfer. I don't know if allowed ng 500,000 sa online, parang hindi yata. So, one time, big time. So, unless nandun ka sa bangko siguro. So, hindi yan i-allow. Automatic reported siya kay MLC. But for casinos, kapag casinos ka, one bank day transaction, 5 million, i-report kay AMLC. Kapag real estate developers and real estate brokers, 7.5 million na cash. Cash lang dito sa dalawa kasi ito yung nagbagsak kabigla ng pera. Kung hindi yan dinaan sa cash, then it will, chineke mo yung bayad kay broker or kay developer, then na more than 7.5, hindi ka nga i-report ni broker or developer, pero i-report ka naman ng financial institution, ni bangko. Kasi pumasok yan dito sa 500 threshold niya. So that would be our reporting transactions. Automatic po yan, nire-report. Pwede po ba natin pigilin yung reporting? Hindi po. Required po sila i-report yan. Hindi po ba yan violation ng batas na nire-report? Hindi po. Required po yan sa law. Hindi rin yan violation ng Data Privacy Act. Under the Data Privacy Act, exempt po ang mga covered persons from their reporting obligations. Ini-inform po ba? Hindi naman po ako yung client, hindi naman ako ini-inform na nire-report pala yung transactions ko. Hindi po kayo kailangang i-inform. Wala pong requirement na ganun. Actually, under the law, if covered persons inform you that they are reporting you to the AMLC, they can be held liable for breach of confidentiality. They can be held criminally liable. Actually, liable pa sila. Bawal nilang sabihin sa inyo na nireport kayo sa EMLC. But for covered transaction report, wag po kayong mag-alala. Isipin nyo na kapag 500,000 and up, talaga pong marereport, or in excess of 500,000, ire-report po talaga. Ire-report. Wala po tayong magagawa doon. I think this was mentioned by the Executive Director kay Mariel when we had the talk. Yung mga BSP employees na siguro may pera na more than 500,000 at nag-withdraw at nilipat sa ibang account, automatic i-report din sila kay AMLC. BSP employees na sila pero i-report din sila kay AMLC. Kung merong mga real estate broker na biglang may nagbayad na 7.5 kahit taga BSP pa yan, kahit taga Amlc pa nga, at ginawa nila to, i-report din sila kay AMLC sa amin as an institution. So that is a covered transaction. Hindi po ba maliit ito, transaction ng 500,000 for the reporting? Actually, this one is fixed by the law, but kung maliit o malaki, as you can see, so far hindi siya inaamin pa ng Congress. So Congress sees fit na 500,000. And hindi lang naman po logistics industry ang ganito yung transactions. I know there are a lot of other industries na more na millions or perhaps billion yung transaction in a daily basis. And are they reported to the AMLC? Yes po, they are reported to the AMLC. So that goes for the covered transaction reporting. Just one last question ninyo. Liable po ba ako for money laundering kapag na-report by covered transaction, under covered transaction reporting? Hindi po kayo liable. Hindi po kayo guilty for money laundering. Unless you are, of course, guilty talaga ng money laundering pag na-report. Hindi po kayo guilty. Ano lang po ito? This is requirement under the law. it's form parts of the AMLC database. So it's a sort of monitoring tool on the end of the AMLC and a part na rin ng customer due diligence on the part of the covered persons. So I think wala masyadong concern dito sa covered transaction reporting, but what we can have, the next kind of reporting would be the suspicious transaction reporting or suspicious transaction report, which is required to be reported within the next working day. Ano po itong suspicious transactions report? If a client commits performs any of these, if that transaction of the client falls under any of the suspicious transactions, then that would be reported by the covered person as a suspicious transaction. And what we must emphasize in suspicious transaction is that it is regardless of amount. Kahit po below 500,000 yan or below the reporting below the threshold, you can be reported as having committed a suspicious transaction in a suspicious transaction report if it is determined by the covered person that there are reasonable grounds to suspect or based on reasonable suspicion that you have committed any if your transaction falls under any of these suspicious transactions. The first one would be there is no underlying legal or trade obligation, purpose, or economic justification. Bigla ka po, for example would be in the account of your company, you are daily, you are the usual transactions would amount to 200 to 400,000. Bigla may pumasok na 10 million sa account. Hindi alam definitely hindi naman natin ini-inform yung bangko o may papasok akong pera, merong investor, hindi naman natin ini-inform yung bank diyan. So anong gagawin ni bangko? Biglang merong malaking pera and the bank is unaware of any underlying legal or trade obligation, purpose, or economic justification. The bank may report that, or the covered person may report that as a suspicious transaction. Wala namang underlying trade or legal obligation. I-report yan as a suspicious transaction. Ang usual na example ko nga dito when just an example would be biglang may pumasok sa account ninyo na 100 million. You're a regular employee, say regular employee of the of a company, and then may pumasok na 100 million. Automatic i-report kayo ni bangko as or the covered person as a suspicious that deposit is a suspicious transaction. But are you liable for money laundering? Hindi po. Unless you are, of course, sabi ko, unless you are indeed engaged in money laundering. But you can prove later on kung matanong kayo or tawagan kayo ng bangko, sir, ano po itong malaking pumasok? Nanalo ako sa loto, napamanahan ako ng may namatay na relative, napamanahan ako, na-receive ko na yung inheritance ko. So, then ma-explain na nila. But definitely the bank or the covered person may report that as a suspicious transaction. Another instance would be the client is not properly identified. As mentioned earlier, there must be KYC principle, KYC, know your customer principle that is being done by the covered persons. But it may happen that upon, and as mentioned earlier, they conduct verification. So submit ka ng form. If later on open an account and then the banks or covered person would later on identify na may mga falsified documents doon or hindi accurate yung kaka-declare, and to the point that the client is not properly identified, then your subsequent transactions or your previous transactions may be flagged as a suspicious transaction on the ground that the client is not properly identified. So i-report siya ulit sa AMLC that the client is not properly identified. The amount is not commensurate with the client's business or financial capacity. Ito ay very easily makikita. Bakit? You open an account, when you open an account, especially for juridical persons or corporations, hihingan kayo ng mga perhaps yung articles of incorporation or other financial documents. Halimbawa, nakita doon na ang capital mo lang is 600,000 but your transactions are billions in pesos, definitely that will be flagged as a suspicious transaction. Bakit? Those transactions will be flagged as suspicious transactions. Bakit? Kasi nga it is not commensurate with the client's business or financial capacity. Ang capital mo is 600,000 pero yung transactions mo ay billions. So, and same if you are an employee of a company, meron kang inopen na bank account, chinek mo doon yung source of income as employee, magkano estimate, you indicated there 50,000 pesos. And yet, your transactions there in your account involve 1 million, 2 million on a weekly basis, then definitely the bank will flag that as an amount not commensurate with the client's financial capacity, and it will be reported as a suspicious transaction. Then we also have the so-called structuring. Ito pong nasa taas. Yung pong structuring, akala nung mga magagaling sa money laundering, yung may alam sa money laundering, they can avoid being reported here as a covered transaction if they cut yung amount ng deposit nila. Kung 500,000 yung threshold, edi gawin natin, mag-deposit tayo ng 490,000, 450,000 every day. Kasi one banking day itong 500,000 eh. So pag nag-deposit ka ng 490,000, 485, 475, 495, 498, yung una mong deposit maaring hindi pa ma-detect ni bank. Pero you make a second deposit the second day or the third day, definitely the bank will notice that. May system na ang mga banko I think hindi naman tumano-mano na iniisa-isa. It's already in the system. They can easily detect if what you're doing is you are trying to circumvent the reporting threshold, the covered transaction reporting, and that will be treated as structuring. You are structuring your report, your transaction so as to fall below the reporting threshold. The bank will treat that as a suspicious transaction and you will be reported accordingly. Kesa kung ganun yung ginagawa mo. Unless of course, talagang yung at that time, may mga clients ka na binabayaran na ganun yung amount. Then you may be reported na structuring, pero again, if later on asked, bakit ganyan transaction? Kasi legitimate payments. Halimbawa, talagang 490 yung goods na babayaran or 490 yung expenses na kailangang ilabas. So, then just prove it by legitimate expenses talaga or legitimate disbursement of money. And then we have the deviation from the client's profile and or the past transactions. Yun nga yung example ko rin kanina, yung usual transaction mo within a week, within a day would range from 200 to 400 million. 2 million to 4 million perhaps within a day. 2 million to 4 million. And biglang nag 100 million, 200 million within a day. The bank will definitely flag that as a suspicious transaction because there is a clear deviation from the client's profile and or past transactions. If a flag lang yun as suspicious transaction, i-report sa EMLC. And then, if it is transaction is related to an unlawful activity or money laundering activity or an offense that is to be committed or has being committed. So halimbawa, public knowledge, si ganito ay involved sa money laundering dahil nabalita na si ganitong politiko ay hinahanap, may balita, ganitong politiko ay hinahanap because of his involvement sa corruption, ganyan. And then, that politician would withdraw money. If he withdraw the money, then it appears that he is known to be involved in an unlawful activity that has been committed So, dapat i-report yan ni covered person. And ultimately, of course, the sixth enumeration here is not exclusive. It is there may be other circumstances that are similar or analogous to the foregoing that would merit suspicious transaction reporting as well. Yun nga yung yun yung maganda rito. In suspicious reporting, we cannot close the possibility that the money launderer would be able to devise new ways to attempt to circumvent money laundering. So we have an open-ended analogous provision under the law. So you will be, and again, sabi ko nga, baka po matatakot, pag po ba na-report ay liable na for money laundering? Hindi po. Paano po pag suspicious transaction? Hindi rin po. It's just that these CTRs or STRs, yung suspicious transaction and covered transaction report, they may be used as part of evidence in the investigation or possible trigger for possible investigation. Hindi naman po kayo ipipinpoint na sige ganito, merong pumasok na 10 million based sa suspicious transaction report. So investigahan na natin siya. Hindi naman po ganon. We usually, sabi ko nga, AMLC, the money laundering is a derivative offense. As a derivative offense, there must be a predicate offense. Kailangan may ma-establish na predicate offense muna. So if a person has been involved in any of the predicate offenses such as kidnapping for ransom or hijacking or smuggling or tax evasion tsaka palang magti-trigger din on the end yung money laundering on our end. The AMLC will not investigate these unlawful activities. Sobrang dami namin kailangan gawin for money laundering and terrorism financing. We cannot investigate yung mga, or we do not primarily concern ourselves with the investigation of the predicate offenses, but we leave that with the appropriate government agencies such as the law enforcement agencies. So, ayan, nililinaw ko lang po, CTRs and STRs are not necessarily proof that the customer is involved in unlawful activity. And it is, as mentioned earlier, an exception to the Data Privacy Act. And sabi ko nga po, kanina bawal kayong paano po STR? Pwede po ba namin malaman na finailan kami ng bangko ng STR? Hindi rin po. Bawal po yun. Hindi po kayo inform ni bank, ni covered person that an STR has been filed. Pwede ko ba kasuhan yung bangko kapag hindi nila ayaw nilang sabihin sa akin yung na-report nila ako? Hindi po. There is a so-called safe harbor provision. No administrative, criminal, or civil proceedings shall lie against any covered person for having made a CTR or STR in the regular performance of his duties. So kahit na hindi na-prosecute yung persons involved, you cannot file a case kasi merong so-called safe harbor provision. And sabi ko nga kanina, in fact, bawal i-inform tayo, mga clients ng covered persons that we are reported. In fact, bawal tayo inform, bawal inform ang public, bawal i-media or i-email or any form. Yeah. If they do that, it is a breach of confidentiality and may corresponding criminal penalty. All right, so let's leave covered persons and now this one is very brief. Mabilis lang po itong investigation and prosecution, but I just want to highlight ano po bang ginagawa dito sa mga money launderers na to. And paano po kapag na-involve yung account namin, I think na-mention kanina, baka may mga account ng mga brokers or forwarders na na-freeze, ano ang pwedeng actions na gawin. So everything begins with a financial investigation. Hindi naman po the AMLC will definitely conduct an financial investigation first before doing any court actions. Ano po yung financial investigation or ano po yung nagtitrigger dito? Suspicious transaction reports may trigger or covered transaction reports may trigger, but it is usually accompanied by referrals from law enforcement agencies or appropriate government agencies such as the Ombudsman. So pag may ni-refer sila or yung law enforcement agencies natin, PNP, PIDEA, even the Bureau of Customs, kapag nag-refer sila ng cases, we will start a financial investigation. So, and how do we proceed with financial investigation? So of course, technically secret po ito, but the usual investigation that we have also for law enforcement agency, but instead of focusing on, but here what we focus would be the financial aspect, the banks, financial documents, financial statements, yan po yung tinitignan sa financial investigation. And one power that has been granted under the law to the AMLC is the bank inquiry, the authority to inquire into bank deposits on both non-bank financial institutions as well as banking institutions. So we can inquire into bank inquiry. There is no violation of the secrecy of bank deposits or RA 1405 and the foreign currency deposit unit law, as well as the general banking law. Express provision po under the laws na exempt ang AMLC in conducting bank inquiry pursuant to its mandate to investigate money laundering and terrorism financing. So we conduct bank inquiry. How do we do this? It can be done without court order. Pwede pong may court order, pwedeng wala. Kailan po walang court order? Pwede itong walang court order under the law kapag ang involved ay drugs, terrorism, kidnapping for ransom, hijacking, destructive arson, and murder. Hindi na po kami pupunta sa court because of the perhaps the need for more expedient action. Pag ganito yung mga involved, the AMLC can through a resolution can immediately ask or issue an authority to inquire into deposits or conduct bank inquiry. But generally, for all other predicate offenses, we do file with the Court of Appeals. The Court of Appeals would now act will review the petition, and then if it finds there is probable cause that there is a need to inquire into the bank deposits, then it will issue an order of bank inquiry. So, ayan. So, pagka na-conduct na yung bank inquiry, na-check na yung nag-file ng bank inquiry, we usually accompany this bank inquiry with a petition to freeze. Bakit po pini-freeze? While investigation, we want to preserve the assets, the funds in the accounts, or kung property yan, halimbawa mga kotse or kaya trucks, we file it with the appropriate with the LTO, with the appropriate government agency. Kung barko yan, with the marina. So depende kung anong nature ng property, and we have transactions na na-freeze na ng mga ships and trucks, cars, vehicles na na-freeze na. So ano po dito sa pagka-freezing naman, we file it with the Court of Appeals as well through a petition to freeze with the Court of Appeals. May 24 hours to act ang Court of Appeals, and then if it finds that there is probable cause that the property sought to be frozen is involved in money laundering or any of the unlawful activity, it will issue a freeze order for 20 days. During the 20-day period, the Court of Appeals will conduct a summary hearing to determine whether or not to lift the freeze order. Paano po or to extend it? If the Court of Appeals deems it proper to extend it, it will be extended into up to 6 months. 6 months po yung freezing. After 6 months, automatic malilift na yung freeze order. Paano po if before the 6 months, 6-month period, gusto nyong ipa-lift yung freeze order? Then you have to file a motion with the Court of Appeals for a motion to lift freeze order. And the burden is on the movant or sa inyo po to show that the property or funds involved or the funds or property frozen are not in any way related to an unlawful activity. And may mga ganito rin po, and sometimes hindi na kami nag-oppose if kasi initial investigation namin, we find them to be related or there's a probable cause na related to unlawful activities, so we'll file it with the court. The court, upon evaluation, nakita rin na meron nga. Kaya lang, there may be information na beyond sa amin or hindi namin makuha na available lang sa inyo. Kaya pwede nyo i-file yan and pakita nyo na talagang legitimate yung transaction. So, alimbawa, bumili ng kotse, hindi namin yung funds, ay yung pinagbentahan, yung funds ay yung pala, ang hinanap namin, nakita namin is it's related to a unlawful activity. Pero yung funds eventually was shown to be proceeds of a different or legitimate business. Pero yung burden nga po, wala na sa amin because we have established the probable cause. The burden is shifted to the movant to show that it's not related to unlawful activity. And sabi ko nga, we do not oppose if we find it also na talaga nga naman na gano'n. But we oppose sometimes and then we let the Court of Appeals decide depending on how it will appreciate the evidence presented. The freeze order is effective immediately and includes related accounts. So ano po ba yung related accounts? Baka po kasi if you can see, usually we name of course we put the name of the person in our petition to freeze as well as the bank account. Then we also include some related accounts. We include these related accounts because considering the intricate and diverse web of interlocking accounts that a person may create in different covered persons or say banks, and the high probability that these accounts are utilized to divert, move, and conceal and disguise the monetary instrument or property subject of the freeze, we usually include in the petition for the freezing of the related and material accounts. When we say related accounts, they refer to accounts, the funds and sources of which originated from on or are materially linked to the monetary instrument or properties subject of the freeze. Regardless of the layer of accounts that the funds have passed through or transactions that they may have undergone. So basically, if we find that the source of funds originated from the account of the freeze, although it is not the main subject of the freeze, then it may be treated as a related account. And that will be frozen accordingly. Materially linked accounts basically are those accounts, although named under the account or owner whose account is being frozen, but perhaps named in the name of another person, but ultimately the beneficial owner is the account owner whose account is the subject of the freeze order. Kumbaga, ginamit lang ibang pangalan, pero yung beneficial owner talaga, yung ultimate owner ay yung sa kanya. So can banks do that? Can track that? Yes, sometimes the bank has the capability to track those materially linked accounts. So kasama yan sa ma-freeze. So as mentioned earlier, ang freeze order ay 6 months. Kung wala pong na-file na forfeiture proceeding, ang mangyayari po dyan ay matutuloy po ang tuloy lang pag walang na-file na case to forfeit the assets, then malilift na po yang 6 months after 6 months. Pero kung may na-file na case, magtutuloy na po yan, ibababa sa regional trial court. The Emlc will file the appropriate civil forfeiture proceeding. Hindi po nare-restrain ang freeze order except by the Supreme Court. So, on the part of the covered person, anong ginagawa kagad nila? Fini-freeze, nagsasubmit ng return kay Emlc, including the amount na freeze. So, pag na-freeze po, so ano pong gagawin na step? So, 6 months. Meron 6 months to investigate, to complete the investigation and to file the so-called either money laundering offense, complaint for money laundering, or kung hindi naman pa, pwede rin naman na civil forfeiture. It's a civil case. Either a criminal or a civil case ang ipa-file, or both. Kung civil case, it's called civil forfeiture case. A civil forfeiture, pina-file po ito sa regional trial court, and it is a non-conviction based asset forfeiture. Basically, it's a civil case. Ang aim lang nito is to forfeit the proceeds of unlawful activity. Hindi po i-hold na liable for money laundering yung person involved. Yun lang pong asset ay kukuhanin because it is to be forfeited in favor of the government. Or in some meritorious cases, kung mapatunayan na yung proceeds na yun ay belonging to a innocent third party who are victims, then it may be returned to the victims, depending on the order of the court and based on how the victims will be able to prove his claim. And then, so sa civil forfeiture, meron ding, so di ba 6 months lang yung freeze order? Pag na-file na yung case, yung civil forfeiture case sa court, magkakaroon niya ng so-called parang freeze order din, pero ang tawag natin ay asset preservation order. So it's either PAPO, provisional lang, tapos after summary hearing, magiging asset preservation order. Kumbaga, naka-freeze pa rin yung assets until judgment. So the burden again, if you want to have this lifted, is on the owner of the property or the funds to show na hindi siya related or dapat ma-lift yung asset preservation order. Kasi remember, this will be effective until judgment. Kung may 10 million ka na freeze at na-issuean ka ng asset preservation order, until tumatakbo yung kaso, naka-freeze lang yung pera mo doon sa bangko. Hindi mo pwede siyang galawin. Unless you file a motion to lift, to show na hindi siya indeed liable o hindi siya involved sa money laundering. Then we can also file a money laundering offense. And as mentioned earlier, merong unlawful activity, yung smuggling, drug trafficking, bribery, corruption. Pwede ka ma-charge both. Pwede naman isa lang. Pwedeng either or pwedeng both. So you can be charged both and they will proceed independently of one another. So here I'm showing just a table of penalties. We have penalties for money laundering, 7 to 14, 4 to 7 years. Ito naman is for the covered persons, up to 4 years of imprisonment. And those who knowingly participated, 4 to 7 years then. So, just an information. So, minsan baka gusto niyo, kung magtatanong kayo about ng information from the Amlc, and unfortunately we cannot reveal any information that has been processed unless it will form part of public knowledge or yung allowed lang na i-disclose. So, kasi under the law, we are prohibited or constrained. So, although we have rules on information sharing, in that regard. And last slide would be the so-called mutual legal assistance among states. We just want to highlight this because, again, as mentioned at the start, money laundering is a transnational offense, so it cuts across borders. So we really extend cooperation with other foreign jurisdictions in investigations of money laundering as well as terrorism financing. And we do have collaborations with a lot of countries, with the US, Australia, Asia Pacific region, or Southeast Asia, with respect to mutual legal assistance. Kasi nga, we note that this kind of undertaking is not solely limited to our jurisdiction. It cuts across border. And with that, I end my presentation. I hope you understand, and if you have questions, you can raise the questions. Thank you.
The first question, aside from the legal implications of AML law violations, would there be tax implications as well? That is, whether the subject transaction is assessed as well for taxation with the amount assessed imposed on the AML law violator? If so, would this mean that there is coordination between AML and BIR?
Yes. Definitely there will be coordination with the AMLC and the Bureau of Internal Revenue. And as to the question, let me just try to get this if I'm correct in the understanding. If the tax implication, if there is a lawful process of lawful activity, that would also be considered as there will be a tax implication in the sense that the money launderer is evading the payment of due taxes, because in taxes we are tax based not only based on legitimate income but or from all sources of income. So we are taxed, and you can be money launderer can be charged for tax evasion as well. But if the BIR has already collected fines relating to or recovered already the proceeds of that unlawful activity, which is based on tax evasion, the AMLC will no longer institute forfeiture proceedings. So basically, there will be no double recovery. What we're saying is that there will be no double recovery for monetary instrument proceeds, which are or proceeds of unlawful activity representing the tax crime or tax evasion.
So yung tanong niya, is there coordination between AML and BIR?
Yes, definitely.
Yes.
We do.
Thank you again, Attorney Buenaventura. Before we sign off, there is one pahabol that we can share with them, this question. What happens to the freeze order when the prosecutor did not recommend the filing of information against the subject person? And you had answered that the freeze order will expire after 6 months. Would you like to add anything there, Attorney?
No more.
Clear naman, clear. Well, ladies and gentlemen, in behalf of the Philippine Multimodal Transport and Logistics Association and PortCalls, my name is Mariel Cleachco, and I'd like to thank everyone for joining us in the webinar. Of course, our dear speaker, Attorney Ronel Buenaventura, and his team at AMLC. Magandang araw po sa inyong lahat. We hope to see you again. Thank you so much. Goodbye.
Thank you.
Have a good day. Thank you, Attorney.